Good morning, ladies, gentlemen, members of the press, human rights experts. Welcome to the Geneva Press Club. Welcome online as well for the people following us live stream on the Geneva Press Club webpage or on our social medias. The Geneva Press Club is pleased and honored to welcome the National Council of Canadian Tamils for a conference entitled Advancing International Accountability in Sri Lanka. Welcome to today's three high-level panelists, and I have the great pleasure to give the floor to the event moderator, Rugsha, Sivanandan, for the presentation of the panelists. The event will be both in English and Tamil. So please, you have the floor.
Good morning, everyone. We would like to sincerely thank and welcome all members of the media, human rights activists, Tamil diaspora organization representatives, supporters, and guests who took the time to attend today's panel, both in person and virtually, focusing on advancing international accountability in Sri Lanka at the Geneva Press Club. With the participation of expert panelists in international law, human rights, and civil society, we hope today's panel discussion will truly foster an understanding of the current situation in Sri Lanka. The panelists will also highlight human rights and international law implications, emphasizing the importance of global solidarity, and hope to empower you all with exploring avenues to enhance and complement the multilateral system's ability to advance international accountability for Sri Lanka. It gives me great honor in now introducing today's panelists: international criminal rights lawyer Alain Werner, international criminal rights lawyer Myriam Bouazdi, sexual and gender-based crimes investigator at the United Nations, Dubé Gagnon, and Tamil Civil Society Forum member, Sri Jnaneswaran. I would also like to introduce myself, Rugsha Sivanandan, Executive Director of the National Council of Canadian Tamils. It is my pleasure to moderate and participate in today's panel discussion. The National Council of Canadian Tamils is hosting today's panel discussion at the Geneva Press Club in partnership with many international Tamil diaspora organizations. At this time, we sincerely thank and acknowledge the following Tamil diaspora organizations who have attended today's panel and provided their support and collaboration: the International Council of Elam Tamils, Pasme Thayaham, India, Norwegian Council of Elam Tamils, Norway, United States Tamil Action Group, United States of America, Maison du Tamilelam, France, International Center for Elam Tamils Rights, UK, Australian Tamil Congress, Australia, Tamil Movement Against Genocide, Mauritius, and the Solidarity Group for Peace and Justice in Sri Lanka in South Africa. As we begin today's panel discussion on advancing international accountability in Sri Lanka, we hope to start off by providing an overview of the current situation in Sri Lanka and highlighting the importance and need for international accountability in breaking the entrenched systemic impunity and evasion of justice in Sri Lanka, holding the perpetrators accountable and achieving remedial justice for the Tamil people. Since 1948, the Sri Lankan state has carried out war crimes, crimes against humanity, and acts of genocide against the Tamil people, and in 2009, we witnessed the heights of Tamil genocide. The Tamil people in the island of Sri Lanka have long endured deliberate Sri Lankan state-sponsored schemes aimed at destroying the attributes of the Tamil nation, threatening their safety and existence. The ongoing genocide of the Tamil people is being perpetrated through various acts of Tamil genocide, such as Sri Lankan state-sponsored surveillance, intimidation, harassment, arbitrary arrests, violence, torture, Buddhization, colonization, militarization, singleization, and systematic land grabs. These acts are intended to sustain the subjugation and accelerate the erasure of the Tamil people as a nation on the island of Sri Lanka. The Sri Lankan state continues to use the Draconian Prevention of Terrorism Act, PTA, which the United Nations Human Rights Council has called to be repealed to harass and incarcerate Tamil people. The Tamil people's right to openly and publicly commemorate and memorialize their loved ones remains under threat. Furthermore, the state continues to employ various departments, including its archaeological and forestry authorities, to carry out state-sponsored land grabs, Buddhization, and singleization in an ongoing effort to erase attributes of the Tamil nation. Sri Lanka has a long documented history of abrogating agreements made with Tamil people's leaders over the past 7.5 decades. The UN Human Rights Council has passed multiple resolutions aimed at delivering justice to the Tamil people. However, the Sri Lankan government has made no tangible progress in implementing any of these recommendations. It must be reiterated that Sri Lanka has violated all 30 articles of the Universal Declaration of Human Rights against the Tamil people with complete impunity. Successive governments in Sri Lanka, including the current one, have come to power and stayed in power by pledging protection to members of the armed forces and others implicated in mass atrocity crimes committed against the Tamil people since 1948, thereby entrenching a culture of impunity, denying accountability and any form of remedial justice for the Tamil people. This leaves no hope in Sri Lanka's state-owned domestic mechanisms. None of the perpetrators have been brought to justice, and Sri Lanka's state-owned domestic mechanisms have consistently and miserably failed. Sri Lanka's persistent unwillingness makes it unmistakably clear that only a fully internationally owned, credible, international, independent, investigative, and prosecutorial mechanism, one that has the trust and confidence of the victims and survivors of the Tamil genocide, can uncover the truth, hold perpetrators accountable, and deliver remedial justice. The recently discovered mass grave site at Chammani stands as one of the most painful testaments to the genocide endured by the Tamil people. The visit by the UN High Commissioner for Human Rights, Volker Turk, to this site on June 25th, 2025, has reignited the urgency of the Tamil people's long-standing demand for a fully internationally owned mechanism, and has once again brought this call to the attention of the international community. While international initiatives, most notably the United Nations Human Rights Council's Sri Lanka Accountability Project, SLAP, are engaged in the important work of gathering, preserving, and analyzing evidence, the Tamil people still continue to await meaningful international accountability and remedial justice for the Tamil genocide. Representing a Tamil Canadian organization today, it has been a privilege to be a part of various forms of advocacy work in Canada and internationally. During the past 16 years, different levels of government in Canada have made important contributions in terms of achieving recognition, accountability, and justice for the Tamil genocide and combating Tamil genocide denial and distortion. Starting from the motions that have been passed at different levels of government in Canada at various times recognizing Tamil genocide, Ontario Legislative Assembly passing Bill 104, Tamil Genocide Education Week Act, Canada's House of Commons recognizing May 18th as Tamil Genocide Remembrance Day, Government of Canada imposing sanctions against 4 Sri Lankan governmental officials, including 2 former presidents, namely Mahinda Rajapaksa and Gotabaya Rajapaksa, Canada continuously playing a crucial role in the United Nations Human Rights Council as a core group member to hold Sri Lanka accountable, and Brampton City passing a motion to build a Tamil genocide monument, which was unveiled earlier this year. In addition, Canadian elected officials from all different levels of government have issued numerous public statements at various times expressing their solidarity with the Tamil people and expressing their concerns for the Tamil people's well-being. It is important for advocacy efforts to continue globally to ensure solidarity in achieving international accountability. In our continuous advocacy efforts, we are here today with our panel of experts to explore various avenues to achieve international accountability in Sri Lanka. To speak now on the current situation in Sri Lanka and the need for advancing international accountability, we will now hear from Mr. Sri Gnaneshwaran from the Tamil Civil Society Forum, joining us virtually from Sri Lanka.
I am Dr. Sri Gnaneshwaran, speaking from Tamil Elam. The present government is also exercising the core ideologies borrowed from the then governments of Sri Lanka since the independence against Tamils. The structural genocide is ongoing. Under the name of development, the land grabbing, colonization, suppression of Elam Tamils' voices by employing the PTA, Prevention of Terrorism Act, revisionism of the history of Elam Tamils. All these structural genocide apparatus are employed by the same present government against Elam Tamil in Sri Lanka. The present government is trying to give new dimension of the struggle of the self-determination of Elam Tamil as racialism. We can learn from the head of the state and the deputy head of the state especially by delivering their lectures. We knew that they are trying to give the name racialism than understanding the Elam Tamil's core problem. Therefore, there are no trust in this government as well by Elam Tamils that the present government is be able to give a proper solution for their struggle of self-determination of Elam Tamils. In this view, we are now experiencing one of the mass grave excavation. Ceremony is one of the strongest evidence shows that the genocidal intent of the state. And we are very concerned on the evidences that have been collected from this mass grave, because the Sri Lankan judicial history tell us that the evidences have vanished or disappeared during the investigation. So in this regard, we are very concerned in this excavation and preserving the evidences And we are requesting, the Elam Tamils are requesting, the Bournemouth Protocol should be employed in all of the excavation of the mass grave, especially in the north and east. Because the culprit of the international crime is the state of Sri Lanka. And we have the question that whether the international governments are ready to allow the Sri Lankan state, who is the culprit, to give the justice to the Tamils. In the international legal system, there is no evidences that the perpetrators has the power to give the justice to the international crimes. Therefore, the international governments have the responsibility to establish the international investigative impartial mechanism on Sri Lanka to investigate all these crimes, the international crimes done by the Sri Lankan state against Elam Tamils. We are demanding that. And we have the right to demand because we are also one of the global community living and have the protection from the international law. So therefore we demand the United Nations, including the international government, should establish the international impartial investigative mechanism against Sri Lanka.
To Mr. Sri Gnaneshwaran from the Tamil Civil Society Forum joining us virtually from Sri Lanka. Next, to speak more about the importance of international accountability and the options available for holding perpetrators of war crimes, crimes against humanity, and genocide to account in Sri Lanka, we will now hear from international criminal lawyer, Mr. Alain Werner. Alain Werner is a lawyer admitted to the Geneva Bar in 1999 with a Master's of Laws from Columbia University. He participated on the side of the victims to some of the most significant trials for international crimes of the past 20 years, including 2 former heads of state trials, the trial in Freetown and in The Hague of the former Liberian president, Charles Taylor, in front of the Special Court for Sierra Leone, and the trial in Dakar of Hissène Habré, former Chadian president, in front of the Extraordinary African Chambers. He also participated in the first Khmer Rouge trial in Phnom Penh in front of the Extraordinary Chambers in the courts of Cambodia. In 2012, Alain created Civitas Maxima in Geneva, an international network of lawyers and investigators seeking justice on behalf of victims of mass crimes. The work of Civitas Maxima until today has led to the arrest, indictment, and/or trial of 12 persons of 7 different countries on 2 continents, including the first ever sentence in Switzerland for war crimes and crimes against humanity in front of the Swiss Federal Criminal Court, and the first ever arrest of a businessman for pillage of blood diamonds qualified as war crime. In 2019, Alain was awarded the Prize of Excellence Michael Halperin by the Geneva Bar, and in 2020, he received a lifelong fellowship from the oldest and largest international network of social entrepreneurs, Ashoka. Please join me in welcoming Alain Werner.
Thanks a lot, Rugsha, for your words. Thanks a lot for to the NCCT and the other organizations which are partners in this event. I'm very, very happy to be back here. I was here last year. So I will talk, and I'm very honored to be on this panel with 2 persons of great experience who will talk as well on other aspects, or more maybe UN. But my perspective is really coming from a criminal law background. I did nothing else in my life trying to find criminal justice for victims in front of whatever mechanism, international court or not, we will talk about that. So this is where I'm coming from, and what I will try to do quickly here is to tell you how I see the situation when it comes to possible criminal accountability for Sri Lanka in the world of today, and why, in my view, there is, I think, some hope in some of the endeavor or effort that can be made. But let me start by saying that I have always been very, very impressed by the resilience and by the engagement and by almost the enthusiasm for justice that this community, the Tamil community across the world have demonstrated. And me, I have been working now for 15 years with Quest of Justice, trying to empower the local actor to try to be active in their quest of justice. And it's very, very emulating and moving, frankly, to see how much this community is trying to advance this quest of justice, recognizing, and we always did with Civitas Maxima, that not only all victims want justice, some victims want to forget, some victims think that this is up to God. So I think justice is not at all the only way, but for some victims it is very, very important. And I think, again, this quest of justice from the Tamil has been very, very impressive. And as Rugsha said, many things have been achieved at the UN. I think you mentioned it, obviously. The recent visit of the High Commissioner is very, very significant. All the resolution. There have been a lot which have been achieved. From my perspective, with my eyes, from my background, obviously, so there was already talk and mention about the need, and this is obvious, of an independent investigative mechanism at the international level, which is needed. This is clear. What has been lacking, obviously, is a criminal case for the international crimes which were mentioned. That has not been happening until today. And this is what I want to talk about, to see why it didn't happen yet, and what is possibly the hope, or what could be done, which maybe has not been done before, in order to come that way. I think we would all agree on this panel that the situation today, the fact that no perpetrator for what has happened have been held accountable criminally in a court of law until today, is obviously a failure of many people, obviously the Sri Lankan government, the international community, the United Nations. So there is clearly a failure. They have failed the victims for many, many years. This is absolutely clear. And you know that there is obviously there is a number, again, as I said, the number of things which were done, but this was not done, and clearly, very clearly, this is a failure. So, what can be done which possibly have not been done? So, my job is to try to facilitate justice outside the country where the crime occurred, when there is obviously no possibility where the crimes occurred to get justice. Because we all agree that if a crime occurs in Geneva, there should be justice in Geneva. If a crime occurs in Colombo, there should be justice in Colombo, and so on and so forth. So justice, first and foremost, is territorial. Where it happened, there should be justice. This is the way it should be done. And we are in a scenario, obviously, where this does not happen. And where we have been working with Civitas Maxima, it's the same. It's different scenarios, but always the same situation. Where there should be justice, there was no justice. So how could we do? And this is today this possibility for several years now, which we call extraterritorial justice. So the idea is to try find a venue for justice outside. And we have to understand that this is outside the UN, this is outside international court mainly. This is really using national court, but which are not the national court where the crime occurred. And you have many ways or several ways to do it. And with Civitas Maxima, my organization, we have explored several of those ways to be concrete and to give you concrete example. Here in Switzerland, which is great, someone can be arrested if there is of any nationality, doesn't need to be Swiss, if he or she, against he or she, there is evidence of international crimes. Even if that person didn't do anything in Switzerland, even if that person is not Swiss, even if that person didn't do anything against Swiss nationals, you can arrest that person. And you mentioned it, Rugsha, this is what we did with someone who we accused of crimes in Western African Liberia. He was living in Switzerland for 15 years, was not Swiss, didn't do anything against any Swiss people, didn't do nothing in Switzerland. We got a war crime case and a crimes against humanity in front of the Federal Criminal Court in Bellinzona. Switzerland is great for something else, is that Aliukosha, that's the name of that person, was living in Switzerland, but Switzerland is possible even if that person is coming only 2 days to visit or goes to see his doctor, his banker, or buying watch or chocolate, doesn't matter. If that person is in Switzerland, that person, by the presence of that person, there could be a case. This is different, for example, in France or in Belgium, where, as far as I know, you need to live, you need residency. So each country is different, but in many European countries, you have those laws and you have units of state employees, prosecutor investigators, which are working on that. So this is a great possibility that we have been exploring with Civitas Maxima. And then you have other possibilities. Everybody is talking about Argentina today, because Argentina has a system where even if there is no presence, someone doesn't live there, someone doesn't go to visit, you can initiate a case in Argentina without any link. So this is another possibility. And then quickly mentioning, because we have cases in United States, we have been exploring possibilities with immigration, where someone goes to the United States, applied for a visa, lies about his past, about what he did before. This is a criminal offense, and you can go after that person. So you have many possibilities. Now, the complexity, if we come back to Sri Lanka, the complexity with that is that all the cases we have had requires something, which is documentation. Okay, of course, if someone comes to Switzerland and you don't know what that person has done, it will be probably too late by the time that person leaves, unless obviously that person is resident. But you need to have documentation already in place. You need to have case file, you need to have information, you need to have good facts in order to build the case. This is one. But of course, the scenario I just told you about requires movement. So that requires that someone, let's say from Africa, for Sri Lanka, whatever the scenario, travels or lives there. And this is what we were able to do, because we have been working a lot on Liberia, but not only with Civitas Maxima, and many former rebels in Liberia or former people in government, they were moving. They were on the move. They were seeking another life in Europe, or they were refugees somewhere. So this is how we managed to do. So this requires movement. Now, quickly, what do we do in a case, in a scenario like Sri Lanka, where the people allegedly where there could be a case against them are moving maybe to China or moving to places that do not have those laws? Because if someone moves to China, we cannot initiate anything. I don't think any Chinese court will entertain any case such as the one I have been explaining. So how do you do that when you are in a scenario when actually there is no movement? And I'm sure Ms. Gagnon will be able to talk about that much better than I can do. But this is a little bit the situation with the UN mechanism, which is here in Geneva called the IIMM, where you have a mechanism funded by the UN in a situation which is not Sri Lanka, but it's still Asia, but it's in Myanmar. And this mechanism basically collects information for years now with a good budget, collects information about atrocities, and this mechanism in the idea is supposed to give this information to national courts, maybe in Europe, to build cases. So this is a bit this idea. Now, what we have seen with and again, I am under the guidance of Ms. Gagnon, not to say stupid things, but my understanding is that IIMM, years has been working, very important, because this is a depository of good information and evidence that could be used, but we have not seen any case. Why? Again, because you are in a scenario, Myanmar, where the people who would be responsible for the crimes, they don't come to Europe, they don't come to the US, they don't come to countries where the IIMM could give the information and initiate cases. So this is a problem. So in 2 minutes, to conclude, why there is hope then, if you are in a scenario where you cannot use immediately extraterritorial universal jurisdiction to build cases because people don't move, essentially. I think there is hope for 2 reasons. One is that to build, it's one thing to give information to the UN, to the High Commissioner, all of that is one thing. It's something else to build, to have cases ready. And I think, in my view now, the path that has not been at least fully explored by the Tamil community when it comes to Sri Lanka is to have cases, possible cases, ready, with information analyzed as much as possible and cases ready, in case one day, for some reasons, someone travels. So this is one. But the second thing I want to mention is one case which has been an inspiration for me. I have nothing to do with this case, unfortunately, and this case has been very complicated politically, but still I think we need to think outside the box. And if there is no movement, if someone doesn't travel, there was one case on a country which is at least as sensitive as Sri Lanka, because of course Liberia doesn't have big power economically, so Switzerland had no problem opening a case against someone from Liberia, maybe someone against China or United States, it would have been different. But this country is Iran. And obviously we all understand that Iran, if you want to build a case against an Iranian citizen, it's not a small case. And there have been a case in Sweden, the Ahmed Nouri case, which has been extraordinary in my view, because what victims and lawyers did from Sweden and from London, they have made Mr. Nouri, who was in Tehran, traveling to Stockholm under whatever pretext, but he has traveled. He was not going to travel, it was not his plan to travel, but something happened and he was convinced to move to Stockholm. When he came to Stockholm, he was out of the airport, he was his foot in Swedish soil, he was arrested. A warrant was ready, a case was built, He came to Sweden, he was arrested. There was a case against him opened from that minute, started, initiated. He was convicted for international crimes for the 1988 killings of Mujahideen in the prison in Iran. And this conviction was upheld in the Court of Appeal in Sweden. This is a huge achievement of extraterritorial justice in a scenario where there was no movement because nobody from Iran was taking any risk, yet they managed to get someone traveling. Unfortunately, politics, and then this is another big issue, but politics prevailed. What happened is the Iranian abducted a Swedish diplomat working for the EU, and then they sentenced him, I believe, to death, and then there was an exchange of prisoners, so Mr. Nouri today is back in Iran. But when, and obviously this raised massive issues for us, for our field, but still, this shows that you can get extraterritorial justice in the most complicated circumstances, even when you don't have, normally you don't have movement and you don't have a scenario like we had in Liberia, which was easier. Thank you very much.
Thank you very much, Alain. To speak now on the importance of how investigations and documentation efforts can be geared towards international accountability to ensure they are usable and efficient, we will now be hearing from international criminal lawyer, Ms. Myriam Bouazdi. Myriam is an international lawyer with nearly 20 years' experience in international, criminal, human rights, and humanitarian law. She served with UN accountability mechanisms, including the IIIM and the Commission of Inquiry on Syria, and has worked with the ICTY and ICTR. She has also investigated violations in Sri Lanka with international NGOs and advises on justice and accountability processes. Please join me in welcoming Myriam.
Thanks very much. And thank you, Alain. I will follow through your presentation, which is very useful to what I'm about to say. I want to talk first about the recently presented latest report of the Office of the High Commissioner for Human Rights on the situation of human rights in Sri Lanka, which was presented, I believe, a couple of days ago in the Council. And I think, once again, highlights the shortcomings of Sri Lanka, and not just Sri Lanka, also the international community, in granting justice and accountability to victims in Sri Lanka. I think the report highlights, but it's, again, not a new thing, the entrenched impunity that prevails in Sri Lanka. And it raises concerns about the current state of affairs, even in light of the new government. There's mentions in the report of reactions that Sri Lanka has provided to the comments of OHCHR on the accountability processes and legal reforms. But at least to me, it's not quite clear how committed those allegations of wanting to lead further legal reform. I think there is something to the effect of reforming the Office of the General Attorney towards more independence. There's also some comments on perhaps reforming the Counterterrorism Act, which is also problematic, wanting to allow memorialization. And I think I remember last year there were reports on curtailed memorial ceremonies reported by OHCHR in Sri Lanka. It's not the case this year, but that's not to say it hasn't happened. So we see that in essence, I'm trying to say that the efforts towards transitional justice in general in Sri Lanka are not very hopeful, and indeed, for now, the main avenues that we can explore are universal jurisdiction, to put it simply, advocating for processes in national jurisdictions, where perhaps victims are residing, or in certain cases where you don't even need to have any specific territorial link to Sri Lanka. And in this respect, the Sri Lanka Accountability Project, which is supported and hopefully will be renewed, I think it hasn't been yet, and the vote hasn't gone through, has now published that they have a repository of evidence, which contains, I think, more than 100,000 records. And this is key, because when Alain speaks of having case files ready and doing the work, the documentation, because of the state of affairs in Sri Lanka, I think we can all agree that this burden has heavily weighed on civil society organizations, NGOs, international NGOs, who have been doing a brilliant job, and this for years, and are the ones who really carry the voice of the victims and collect what hopefully later will become the evidence that can be submitted if and when there is a case, whether it be before an international mechanism or national courts. I think it's important to realize that sometimes, I've worked as an investigator, and so I know that sometimes we have a bit of a simplistic approach to collecting information, and we don't necessarily always think very much forward in how this material we're collecting will maybe become evidence in a case. And also, having worked on cooperation with the IIIM on Syria, after being an investigator for the COI Syria, I've also seen the life cycle of information that is being collected. And it's very different when you start out working with CSOs or working as an investigator for a commission of inquiry, collecting testimony, which is sometimes almost live, people coming out of detention, explaining, giving you a torture account. And you sometimes get caught up in just catching the story and publishing or using it immediately in a report or whatever it is that you're mandated to do. However, we now have enough time in existence to see that this is the kind of material that gets shared by CSOs, by commissions of inquiries, fact-finding missions, with mechanisms such as the SLAP, collecting it in a repository, and hopefully this would become later criminal evidence. Criminal evidence is held to higher standards than human rights accounts. And this is something I really want to emphasize, because I am also hopeful that accountability will come for Sri Lanka as well. The wheels of justice are sometimes very slow, but I think that there's a lot of requirements that are already gathered in the case of Sri Lanka to really foster a very good and efficient accountability process. Now, in order to do that, there's a number of hurdles that we might run into in the future in order to make this material evidence or have the standards of evidence in a criminal case. One thing I think of in particular, and which I think OHCHR has previously mentioned in its report, it's the need to have, well, it's the balance between the need to have a victim-centered approach to gathering the evidence, and of course, and this is no secret, it's also referenced in OHCHR's reports, the pressures and the intimidation campaign continues in Sri Lanka towards the victims and the witnesses. So we need and want to grant these people the safety that they deserve, and this is in line with the do no harm policy that every investigator should have. And this often does not warrant for consent to share the material. So you have a lot of cases where very excellent CSOs, NGOs will collect testimonies, but will not collect the consent permitting the sharing of the material. And this is a very complex issue. And I can tell you, as an investigator, it's very painstaking to have the consent conversation with the person you're speaking to. It's really not the funnest part of the job, yet this is really what will matter in the future in an accountability process. If you collect somebody's testimony and story coming out of detention, having been detained, it's very likely this person is highly traumatized, completely scared of being detained again or retaliations. They will most likely not want to not give consent to share any of their information with anyone. Yet, I think it's important to really emphasize that we should push to at least collect some form of consent to share, and to as well document the interview or the material you're collecting well enough to be in a position at a later stage to recontact the person. One of the hurdles that those mechanisms are really running into now, and I speak specifically of Syria, is that we sometimes do not have consent to share in universal jurisdiction cases in national jurisdictions in Europe. But we're also not in a position to locate the person who gave the account in order to recontact and rediscuss consent. So it seems a bit technical, but it's really of the utmost importance that we really keep on emphasizing that consent is key, the way that the material is documented as well, in order to raise something to the standards of criminal evidence material. You need to also be mindful of things like the chain of custody, for instance. And that's often something that's lacking when information comes from CSOs and NGOs. That might disqualify information at the trial stage if in case of a criminal trial. So these are things that are, really important to bear in mind when doing the work, but I would also encourage all the stakeholders to have the discussion at every level in order to ensure that information is shared. So to my knowledge, OHCHR's Sri Lanka Accountability Project still has not received any information from governments. I think they are sharing, I speak under your control, Rugsha, I think they are sharing information with jurisdictions on cooperation requests, on the basis of cooperation requests. But I think it would only make sense that if the SLAP is supporting an investigation in whatever country, this country in turn shares back with the SLAP information that they may have on Sri Lanka, on crimes occurring in Sri Lanka. And that, to my knowledge, hasn't happened. So I think it's also an important thing to advocate that this be done in different directions. And the last thing I want to talk about is also, I surely view this as a hopeful sign that states have voted universal jurisdiction. Some states have created and funded international criminal sections within their office of the prosecutor, and some are holding those trials. It's great. Now, when it comes to collecting evidence, in those countries, sometimes, on the case of Sri Lanka, a lot of times, this evidence is available on those states' territories. Unfortunately, it still has to go through civil society organizations, sometimes the UN, in order to go back to national jurisdictions. But in fact, those national jurisdictions, on another level, happen to process a lot of those stories. And they do so in their immigration courts. A lot of the victims who could testify to the crimes which occurred in Sri Lanka are asylum seekers in Europe and other countries of the global north. I want to speak about a case for which there was a press release this summer from a law firm here in Geneva, who picked up a case, the case of Mr. S.E., a Sri Lankan national, who made it to Switzerland, escaped after having been forcibly disappeared, detained, tortured, and escaped, made it to Switzerland where he filed for asylum, and was denied asylum on appeal, and eventually returned to Sri Lanka. His complaint and his allegation, his testimony on the treatment he had received in Sri Lanka was not even considered by the SEM, Secretariat d'État on Migration, I think, Alain, right? He was not afforded the psychosocial support or the forensic expertise that he deserved in order to corroborate his allegation of having been tortured, and he was simply sent back to Sri Lanka. He tried to bribe his way back into Sri Lanka in order to, I assume, assure that he would be safe. And in fact, within a matter of days after returning to Sri Lanka, he was forcibly disappeared in one of the famous vans, detained again, tortured again, and eventually escaped and ran back to Europe, but not to Switzerland this time, to the UK, where he filed for asylum again. There in the UK, he was picked up by a Sri Lanka NGO, a Sri Lanka-focused NGO, who afforded him the psychosocial support he deserved and accompanied him through his asylum case. Eventually, he was granted asylum, and we now have a lawsuit against the Swiss government for violation of their obligations under the Torture Convention. And I think this is a really symbolic and representative case of how we sometimes act in different directions. And there's a lot of space, I think, for advocacy on how to address perhaps immigration and asylum seekers, immigration cases and asylum seekers, and to be mindful that evidence, information, documentation lies there in the first place, at least in Europe. And so we all have to work hand in hand with that. And we have to ensure that people who may and can speak out about the international crimes occurring in Sri Lanka are given a safe haven in order to do that. And this can only occur through cooperation of the UN, national jurisdictions, CSOs, and we need to continue advocating in this favor.
Thank you very much, Myriam. To speak next, we have Julie Dubé Gagnon, who is a Canadian jurist and works as an investigator specialized in sexual and gender-based crimes and gender analysis with a UN criminal accountability mechanism since 2019. Julie was deployed as a sexual and gender-based violence investigator and gender advisor to other UN investigations during the past decade, including to the United Nations Independent International Commission of Inquiry on Ukraine, the United Nations Independent International Fact-Finding Mission on Myanmar, the United Nations Independent International Commission of Inquiry on the occupied Palestinian territories in Gaza, and the United Nations Independent International Commission of Inquiry on Burundi. From 2015 to 2017, she investigated 13 years of conflict in the Central African Republic as the lead field investigator for the CAR Mapping Project. Please join me in welcoming Julie Dubé Gagnon.
Thanks very much to the organizers, and it's nice to be here with Alain and Myriam as well. So I was asked to speak about how important it is to have an intersectional gender approach when working on accountability, particularly from the point of view of an international independent mechanism. So I just want to be clear what that means. So should there be an independent mechanism on Sri Lanka, that means that the mandate would be similar to the ones of Syria and Myanmar, most likely, which means that it has the mandate to preserve, analyze, collect, investigate evidence of international crimes, crimes against humanity, genocide, war crimes, committed in Sri Lanka from X date. You know, each mechanism has its own temporal scope and also territorial scope. But the additional added value of such a criminal investigative mechanism is to actually prepare case files or analytical products that actually support criminal proceedings before regional, international, and national jurisdictions. And this is where it's important to distinguish the work of human rights investigations and criminal investigations and the specific role that a criminal mechanism has. It doesn't launch complaints before these jurisdictions. This is where Civitas Maxima, other victims groups, and CSOs have to lodge the complaint before the jurisdiction. And when those complaints are launched, competent authorities come to the mechanism and ask the mechanisms to share the evidence that they have with such jurisdiction. So I just wanted to make that clear, because sometimes there's a bit of a confusion of what exactly is the role of the mechanism. The mechanisms also don't make their findings public. They work like Office of Prosecutors, collect the evidence and package it in a way that can be used before criminal proceedings. And often these findings are not public. So unlike human rights investigations, fact-finding missions, or commissions of inquiry, it is quite rare that such findings are made public. But it can make some public to actually facilitate criminal proceedings and help CSOs and their lawyers lodge those complaints. So anyway, long story short, why is it important to apply a gender lens in such accountability work? It's important because often comprehensive intersectional gender approaches are at the periphery of accountability work, and Sri Lanka should not fall in that trap. Applying an intersectional gender lens enables us as investigators, as prosecutors, as lawyers, analysts, to think holistically of what it means to be a man, a woman, a boy, a girl, a person with a diverse gender identity and diverse sexuality. What does it mean to live in Sri Lanka's diverse society, as well as the cultural, social, religious, political, legal, sociological factors, power relationships, and dynamics which determine and shape that understanding and give rise to assumptions, stereotypes, biases. So basically, it means that we ensure that the voices of all victims and witnesses are reflected in the mechanism's work. And unless you have a gender intersectional approach, you basically miss out on more than half of the population's story of how they've experienced conflict. And I'm going to explain with examples what this means. But also having a gender intersectional approach prevents conscious and unconscious biases. You can only conduct criminal investigations that fully reflect victims' harm once we understand how gender impacts the way in which victims in Sri Lanka, in Myanmar, in Palestine, in Burundi, in Ukraine experience harm, how perpetrators perceive their victims, the meaning of the harm inflicted on them, and the specific gender dynamics that drive the perpetration of this harm. Perpetrators hit where it hurts. They don't just hit one victim, they hit the victim's entire community, the family members. And we cannot pretend to grasp the extent of the harm or impact on the victim, on the collective community, on the family members, if we do not apply an intersectional gender approach in our investigation and accountability work. Okay, so this is the theory. What does it mean in practice? It means that for criminal investigations, and I think Myriam made a very good point, that human rights documentation often looks at the crime-based elements. As a human rights investigator, I would spend 3-4 hours for each witness that I would interview. As a criminal investigator, I spend 3 to 4 days with the same witness. At the end of the process, we sign a witness statement. The witness has time to review, make corrections, amendments. They sign it. In a human rights investigation, you're not afforded that same time, and it has a different purpose, and that's fine. But the additional value of a criminal investigation within a mechanism is that you go and you look for linkage evidence. You link the perpetration of the crime with the actual responsible, the person responsible for the commission of the crimes. So why am I talking about that with a gender lens? Well, how do you collect linkage evidence? Who are the people you interview to get that evidence, in your view? Well, often we look at insider witnesses, former members of the military, former members of the Sri Lankan military, former members of Sri Lankan armed groups. What is the usual gender of these members? Men, women? Usually it's men. So I will give you one example where I had a defector of a military of one of the countries I was investigating. In the middle of the witness interview, we were asking him a question, and he didn't remember the name of who was the commander of which and which unit that he was deployed to when he was a member of the military. In the middle of the interview, he takes his phone and he calls his wife, because the wife remembers. Because she accompanied her husband within those different military deployments. She knows who she was forced to cook for or receive or be nice to during those deployments. And here I was thinking, wow, we need to start interviewing these insider witnesses' wives, because they remember some very unique details that is key for linkage evidence. That's one example of why it's important to apply a gender perspective. Think outside of the box. What is the gender of the usual perpetrator that we see in such cases for crimes against humanity, war crimes, and genocide? Again, usually it's men that we look at. Women also have a role to play in the perpetration of such crimes. They're not always the most vulnerable, they're not always the victims. Of course, those dynamics come into play, but we also need to apply a gender lens here and look at what is their role. The fact-finding mission on Myriam and Suu Kyi here that what does it look like to apply a gender lens? Also, when you want to build your investigation strategy, what are the usual witnesses that come forward and that are easier to interview? Often, not always, but often in such patriarchal society, it's easier for men to come forward and speak to investigators. They are usually afforded with more technology to have access to international investigators. They have smartphones. It is also more accepted in some cultures to have the men go and speak, on behalf of such and such communities. What are we missing out here? We have to look for ways to speak. Don't usually have that voice, that opportunity to come and also speak about what happened to them, how, why, by whom. So, how do you make that happen? There is methodology that exists to speak to a woman. For example, make her travel outside of her home in a safe house where she has access to internet. We can find intermediaries that provide that technology to her. She can find a mock reason to leave her house, have childcare also arranged so she can speak tranquille, in peace, to the investigators. I will always remember a case when I had to investigate sexual and gender-based violence in the context of Burundi. I was with my team in a school in a refugee camp in the Democratic Republic of Congo, and a young girl had brought her small toddler to come to speak to us. The toddler was acting very cute, being very naughty, running around the room, and it came to my attention that there was something missing in this woman's testimony, in her story. So we arranged for the small toddler to be taken care for by some aunties that were waiting outside. And it's you know, I was on an experience, so quote unquote, this was 10 years ago. And finally, the woman, she was a young woman then, told us that some pro-government militia had come to her house looking for her brother who had participated in protests against the current government, and that they had raped her right beside her father, beheaded in a pool of blood, and that it was because of her brother's role that she was inflicted those crimes. And of course, the small toddler that we saw was a result of the rape. So from that day on, I understood as an investigator that it was absolutely key, important to accommodate women, to have childcare arranged. And I want to make another point here where psychosocial support was mentioned. It is impossible for criminal investigators to interview and capture the evidence of traumatized victims, of women who were raped in detention, of men who were subjected to many forms of torture without psychosocial support. The support needs to be funded alongside collectors and evidence reviewers and analysts and lawyers and investigators. It is absolutely paramount, and if you don't have psychosocial support, you cannot have a victim-centered approach, trauma-informed investigative methodologies, and you don't build your case file reflecting everybody's harm. So I just want to make that point because it really came out strongly from your intervention. I think I've passed my time, but I just want to say, there are many, many misconceptions about what a gendered approach is, and I think I've provided you some examples. So it's not about just investigating sexual and gender-based violence and crimes. There are two separate things. Of course, you need to apply a gender and intersectional approach when you investigate sexual violence and gender-based crimes, but that applies to all crimes you investigate. There are very distinct gender dimensions of all crimes, and they need to be collected, they need to be analyzed, and they need to be included in your case file for future prosecution. So thank you very much. I'm going to end here.
Thank you very much, Julie. We will now be opening it up to those who have joined us in person and virtually for any questions for the panel. So our members of the press club will be passing a microphone to those who have joined us in person if you'd like to ask any questions to our panel. And we will also be monitoring the chat in those who have joined us virtually as well. So please feel free to ask your questions.
Hi, hello, I'm Nisha Piris from Association Culturelle Tamoul en France. I'm based in France. I'm a human rights activist trying to represent the Tamils. First of all, I don't have a specific question, but a remark and maybe a question also. First of all, I wish to salute the panelists for their insightful contributions and the National Council of Canadian Tamils for organizing this important discussion. I also want to acknowledge the Canadian Tamil community who continue to believe in the values of this country that gave them a second chance at life. But at the same time, we must be honest. As Tamils in Canada or Tamils in Britain or elsewhere in France, like me, are we not falling into the diplomacy of the Western world, recognizing May 18th as Genocide Day or banning only the Rajapaksas? Is it sufficient if we do not also demonstrate and confront the genocidal intention of successive governments in Sri Lanka? And at the international level, as part of the core group at the Human Rights Council, Canada has constantly put forward weak resolutions that avoid naming Tamils as the primary victims of systematic violations. Today we hear many references to accountability, justice and war crimes, but are we truly addressing the Tamil people? In most UN resolutions and even in international discussions, the word Tamil is carefully avoided, as if justice can be pursued without naming the victims of these systematic violations, how can we advance genuine accountability if the very identity of the primary victims, the Tamils, continue to be erased? So we need to push Canada to be, for the Tamils, what the Gambia is for the Rohingya people, to take bold legal action and not just symbolic steps to confront genocide before the International Court of Justice. So my question to the panelists is concretely, how can we push Canada to play that role to become the Gambia for the Tamils? And I want to finish by encouraging Rugsha and the NCCT. Your role is very crucial in representing Tamils with a truly victim-centered approach. So please continue to carry the voice of the Tamils victims and resist falling into the framework of Western hegemonic diplomacy. Thank you.
Thank you so much. Appreciate your presence and your question. I will now look at the panelists. Anyone would like to take that one? Yeah.
Thank you for the question. I think it's great because we've just been talking, Julie has just talked about mainstreaming the gender approach. There's another thing that needs to be mainstreamed within all these accountability documentation efforts. It's the decolonization. And this is simply having a decolonial approach to accountability and transitional justice. I don't see those as being mutually exclusive with engaging with international or national community efforts. But for sure, I think we all need to bear in mind that there are political matters behind each and every step that is ever taken towards accountability, truth, justice, reconciliation. The struggle was and will always be for control over the narrative. I think it's clear to everybody. And the only way to make sure that we don't feel like we're, in a sense, well, we, not me, but you, are not betraying what you set out to do is to continue engaging and maintain this approach of decolonizing the discourse. Your story belongs to you and will always belong to you, whether or not you have a trial in a national jurisdiction, whether or not you have an international mechanism. You're only pushing forward the agenda of telling the story, but you never let go of your story. It belongs to you and it will always be yours.
Thank you.
Yeah, maybe let me add. Obviously, I'm very conscious that once I'm talking from Geneva, 2, I am a man, and 3, I'm white. So I'm very conscious of that. From my perspective as well, and this I think I agree with everything which was said. Me, I don't trust government. Governments in Africa, governments in Europe, governments anywhere. I don't trust governments for when it comes to our matter, which is accountability and getting justice. There were talks about, and I think this is very important, victim-centered approach. Give me the name of one government in this world which we can say has a genuine victim-centered approach and is pursuing. None. None. Really none. And Julie was talking about social support. I could talk about security of victims, and we could talk about many things which is completely part and parcel of victim-centered approach. And I can tell you very concretely in cases, this is not the concern of even the most enthusiastic government pursuing accountability. Sometimes they don't care about any of that. So, you know, you talk about Gambia. Yes, Gambia is great because they are pursuing a case in the International Court of Justice. What is Gambia doing for its own accountability for years when civil society have been fighting for years and years and years to get this trial in Gambia ongoing? What about their former head of state who is in Equatorial Guinea, and so civil society doing all kind of effort, including in Ghana, where Ghanaians were killed, in Gambia and all of that? What are they doing? I can talk about Liberia. For 30 years we have been fighting for Liberia to do something. So, me, it's not because it's Africa that it's great or not great. Me, I don't trust government. Frankly, I think that when it comes to accountability, he cares, people, and this is remarkable what you hear, because these both speakers have been working within the system with the UN, so this is very encouraging to think that you have people within the system, within the UN who care that much. I just hope that they will keep their job and keep working within the UN. But you know what? Me, frankly, of course, it would be great to have cases in Africa. We're trying, or in the global south. We mentioned Argentina and other places. Spanish victims are going now to a victim-centered approach. And I think that really this is a mindset. Don't trust the ICC, don't trust international court, don't trust any government. Do it, work yourself, because at the end, victim-centered approach, nobody cares. This is my opinion. At the end, victim-centered approach, nobody cares. This is my opinion.
The commentary from the panelists, and obviously for the Tamil community in Canada for actually hosting. I have a question just around a comment made by the first speaker, and I think it would be kind of reminiscent to kind of like speak to the 6 spaces that we kind of struggle in are very common to the Tamil spaces, and that was one of the reasons we wanted to attend this event. So the first speaker spoke about self-determination. It is the core of this issue for the Tamil community, which has led to gross human rights violations on behalf of Sri Lanka. My question was, do you see the pursuit of justice in criminal courts as a parallel struggle to the greater and ongoing struggle for self-determination for the Tamil community? And what has been your experience in navigating these spaces? Because there are 2 very different spaces. Oftentimes when communities like ours, the Sikh community in pursuit of our homeland of Khalistan, or the Tamil community in its pursuit of its homeland, places like the United Nations and other spaces are not a space necessarily for self-determination talk, but it is for human rights. And then often communities like ours are left to kind of navigate that space in a way. And I really appreciate what was just said, because the limitations of the systems in the pursuit of judicial justice was well put by the panelists. It's still a political space, and I think nothing proved that more than talking about what happened in Sweden, and you know, having a prisoner swap and how powerful some of these nations are, whether it's Sri Lanka in the case of the Tamil people or India in the case of the Sikh people, that it's very difficult to actually challenge these people. And the fear that creeps in, I think, in our communities is that we spend a lot of energy in spaces like the UN trying to get statements or a basic passing comment by a country in our support. And then we lose the essence of what the true struggle was, which was the freedom of our people from genocidal countries like Sri Lanka and India. So really, how have you, and this question might be for Rugsha, for yourself, as a leader in the Tamil community, how have you been kind of navigating both of those fronts, human rights and self-determination?
Thank you so much, and I completely relate to your comments, and thank you for sharing your perspective from your community as well. I think it's been a very long journey in terms of justice, in terms of accountability, and I would like to start off by saying in the state that we're in today, in the time that we are speaking, I do truly believe that without the steps that we have to take first, second, and then third, like I think it's a step-by-step process. And our core advocacy principles or priorities, it starts with first that international recognition piece. So without the international recognition or acknowledgement for what has happened, whether it's war crimes, crimes against humanities, or genocidal crimes that have taken place, there first needs to be an acknowledgement and a recognition that this has happened, and in fact an acceptance. And until this day, there has been no acceptance from the Sri Lankan state that any of this has happened. And only if that takes place, we can even think about accountability. There are some countries around the globe that have said that war crimes, crimes against humanity, and genocidal crimes have taken place. So we have made some progress in terms of international recognition for the Tamil genocide, for example. However, we still have a long way to go in terms of international accountability, and which is the reason why we're having this panel today. And we truly believe in the journey for self-determination, as you referenced. We truly believe that advancing the international accountability in Sri Lanka is what will lead to the end result of what the Tamil people are looking for. And to be very honest, they're looking to live peacefully in their homeland, and we're looking for stability within the Indo-Pacific region. And if that's what we're looking for, with regards to self-determination, whether it's a permanent political solution based on the Tamil people's inalienable right to self-determination, we truly believe that accountability in today's conversation will play a huge role, and I think it's an important stepping stone for us as a Tamil people. And I think the Tamil people truly in Sri Lanka today who are facing the ongoing violations, crimes of genocide, for example, really depend on us as the international diaspora. And I think we have a responsibility to support them. Thank you for your question. Do we have any other questions? Nothing thus far. Yeah, we do have some people who have joined online. I do want to ask one question. I think, Julie, maybe you can start off responding. I'm not sure if it's as relevant, but I think it might be something interesting to consider looking into. One of the very timely conversations, or I should say a very hot topic right now, is with regards to the Chemrani mass graves. And with regards to what is happening right now, it's been 16 plus years since the heights of the Tamil genocide, since 2009. And while there have been various conversations around, what can still be done after this many years. Something like Chemrani mass graves comes knocking on our door saying it's not over. So with regards to evidence collection and what's happening right now in terms of excavations at Chemrani in Sri Lanka, there have been various evidences that come out every single day of photos that are truly disturbing of children, of women sitting in various postures. The way that these images are coming are very disturbing, truly, to the Tamil people. So one of the things we wanted to ask is, what next, especially around looking at evidence collection and looking at an international independent approach for investigation. How does sexual and gender-based violence crimes, or how do we take an approach that is truly holistic in terms of building a case for something like Chemini and the mass graves that we're seeing as we speak today?
I mean, it's a complicated question, but I think that what I can say, I mean, first of all, sexual and gender-based crimes are always the most difficult crimes to investigate. Why? Because of the stigma attached to the crimes, because of the trauma, because victims want to forget and move on with their lives, because the victims have been expelled from their community, that you know, there are just so many reasons that make it more difficult to investigate, but it's not impossible. So the approach, the holistic approach, is to listen to the survivors and also find creative ways to capture the evidence when it's not possible to speak to the survivors. I've spoken earlier about insider witnesses. There is evidence on sexual and gender-based crimes that you can obtain from insider witnesses. You need to ask the right questions. There is evidence you can capture from members of armed groups. You need to ask the questions. You need to ask, are you investigating sexual violence? Are you punishing members of your group? Were you involved in camouflaging, hiding evidence of these crimes, and how? And it's not, and you need to frame the questions also that is culturally acceptable and understandably they can understand to be able to provide the information. And I think that, again, with the holistic approach, I mean, you can have access to medical records if you still have them. You can speak to midwives who've treated survivors when they fled. You can look at numbers of, I don't know, miscarriages, abortions, and there's different data that you can collect also that shows indicia of sexual and gender-based crimes. And I think that once you start speaking to survivors, build the trust, afford support, accompaniment, this is where also it trickles down. It's kind of a snowball effect. Once you've treated and respected and collected the evidence in a healing way for the survivor, other survivors will come forward. So it takes time. You might speak to less survivors, less witnesses, but the value and the quality of the evidence will be there. So that's generally what I can say here.
So I understand where you're coming from, obviously, with the mass graves, and what I cannot talk about is the context, and obviously it's very disturbing then for the community, if indeed then around those mass graves there are a number. But let me tell you one thing about the mass graves, because I thought that was interesting. We had a case, and we are very late this year, but Civitas Maxima is publishing, it will be online Friday on our website, our annual report 2024. We talk a lot in that annual report of a case we had in Paris, universal jurisdiction case. We got a crimes against humanity conviction upheld on appeal. Now, on that case, there was some allegation 30 years ago of murder in a very remote place in Liberia, and allegedly the bodies were there somewhere, according to the victims and survivors, but there have never been no one dug, okay, to look for the bones. And this is a very different situation because Liberia today at least let investigator French coming on the ground. They were cooperating. So this is not at all a scenario where you could say that the alleged perpetrator are kind of the owner of the place because they control the place and they are doing things. But still, this is a scenario where at the end, when we were in court in Paris, there had been nobody dug to look for the bones. And we were talking about a concrete murder, allegedly, by a victim coming to Paris saying that guy killed my relative, and here are the bones, and we knew more or less where the bones were supposed to be, except that nobody dug. And the defense very clearly and strongly said, well, wait a minute, we are in France, this is a criminal case in French court, how come you have a case? You have no body. You don't have DNA, you have nothing. What are you talking about? And you know, in Liberia, the problem is that a French investigator, because this was a French mandate, this was a French case in Liberian soil, you cannot go to rural Liberia and start digging like a French, let's talk about colonial, like a French white guy, and you start digging and taking bones, and then on the plane back to France to do DNA testing, which is not available that way in Liberia, at least for that purpose. So this creates all kind of problems. And we remember there was Ebola in Liberia in 2014. And the big problem with Ebola is that people didn't trust having the corpse of their relative in plastic bags and then in hospital. They didn't trust. And this is why Ebola spread, and there were all that problem. At the end of the day, the victims managed to get the conviction upheld, convince the French jury and judges that yes, there was enough good evidence, substantial evidence, even if indeed we didn't dig for, and we didn't get DNA, because it was not possible in that circumstances in Liberia to start digging in that place. So just to say that I understand all the feelings around that, and that I'm very sorry I cannot say not more, but on the fact that sometimes you can get convictions even if you don't have the bodies and even if you don't have the DNA.
Thank you very much. I think we have another question.
So my question is for Alain. So since you said, I don't believe in ICC, ICJ, or even the government, what would be your approach to get justice for the victims?
Yeah, so this is exactly the right question. And yeah, so my take, as I said, would be universal jurisdiction. I realized after having heard my colleagues that because I talked about movement, that I talked about the problems of universal jurisdiction, where you need movement, you need, at least in Switzerland, in continental Europe, for someone to be there at some point in order to open a criminal case. And then I talked about this Iranian case where you can, some people do attract or invite or whatever, create presence. I realized that I did mention Argentina. There are other countries possible. There is now in the world some countries, and not only Argentina, it's possible in Germany, at least in theory, even if concretely Germans are very careful in which case they selected, but it is possible to initiate cases in some countries without any presence of anyone. We mentioned Argentina. The problems with these venues is that because they are quite exceptional, everybody goes there. So this happened 25 years ago. We were all already in the field with Belgium or Spain, you may remember, in the 90s, where they had these possibilities. We call it pure universal jurisdiction. And as a result, everybody went to Madrid, everybody went to Brussels. Tibetans were against the Chinese. Many, many, many people went against, including against Americans, against Rumfeld. There were cases. And what happened at the end, the American told the Belgium, listen, if you keep doing this nonsense of pure universal jurisdiction with your laws, we move NATO headquarters in 48 hours. What did the Belgium do? They changed the law, because obviously their interest was to keep NATO headquarters in Brussels. So this is always the problems, and today we see many cases, including on Myanmar, but not only. You have as well other cases, including on Ukraine. So you have Ukrainian cases now which are filed in Buenos Aires, But to answer your question, I think that at least all these opportunities need to be very seriously considered, with all the caveats that I think was very, very well said and interesting about the need to be very professional and very meticulous and to build cases which are geared towards criminal prosecution and not with a human rights standard, which, as was said very rightly so, is lower. And if you want to build a case for criminal prosecution, then obviously you need to have more robust evidence, which obviously is a challenge. I hope that answers the question.
Thank you very much. I think we have one question from online, so I think she'll ask the question.
Thank you. We have a question from Tamil Rights Group from Tilak. So he said, I think this is addressed to Alain. You mentioned that you don't trust governments, which is very true. The question for us as Tamils is, while we want to believe in UN entities to advance our struggle for justice and accountability for Tamils, we would like your view on how much we can trust the UN entities to deliver justice for the genocide that has been perpetrated on our people. Would appreciate your thoughts and suggestions as to how we can effectively advance justice and accountability and what needs to change in the UN's approach in this regard. Thank you.
Yeah, so I think I will really, here I need to be humble, and you know, it's fine to reinvent the wheel and always say that we know better or we have other solutions. I think we need to be humble here. I think there have been, and you can see the quality of the staff and the people for years and years who have been working within the UN. I think everything which has been going on in the UN with Sri Lanka is definitely not by any standard a waste of time in the past. So I think this has been very, very important. I will let my colleagues to talk about the value or maybe the limit, or is it the end of the road or not within the UN. That honestly I cannot say. But anything I have been talking about, which if one day this is the way the community wants to go with universal jurisdiction, will have to be built on the strength of what has been going on for years and years and years within the UN. And I think today we see clearly some limitations of the UN, and now we have on top of that obviously all the funding crisis that we have not talked about, but I was there a year ago. Well, a year later, unfortunately, I think the situation is grim in terms of funding and all of that. So I think I will let my colleagues talk about, is it the end of the road or not? The only thing I can say is that don't reinvent the wheel by any way. All this has been going on is very, very important. It will be valuable because this is information, report, know-how, knowledge, all of that will need to be, you know, the material for any subsequent effort. I think maybe you can.
Maybe I would just add, can you hear me? That a UN mechanism, a criminal UN mechanism looking at Sri Lanka would be part of the solution, but not the only solution. Working on Myanmar, on criminal accountability, CSOs from Myanmar constantly ask us, how long will it take? Or what else can be done? The criminal accountability side is not the only solution. It's part of the solution, and there needs to be other efforts in parallel that contribute to justice. And justice has many forms. So I would say it's part of the solution. Continue to support that avenue because in some ways the UN can preserve. They can assist, for example, when there are mass graves, to connect the survivors to laboratories in other countries that do the DNA testing. That's just one example, okay? And it preserves impartially, independently the evidence. So not the only solution, part of the solution. Other efforts need to continue in parallel.
Yeah, I would also like to add that these processes, accountability processes, do not happen in a vacuum. So one has to ask oneself, what would be achieved should we actually secure such a mechanism or any other form of accountability process? And what will it be, but what will it not be also? And I would also, again, bring you back to the latest OHCHR report and the recommendations made on human rights situation in Sri Lanka, where I think it's very clear that OHCHR sees the limitations of, you know, the efforts towards accountability, because it touches on many other aspects, and that is legal reform, amending the PTA laws. There's of course the missing persons mechanism, which I can't remember if it's in the latest or the previous report, but there's some numbers available. The outcome is ridiculous in terms of how many complaints were filed and how many were actually processed. The same goes to the mass graves. The High Commissioner was taken to the Shimane one, but we have other ones in Mullaitivu, other mass graves where OHCHR's very own report states that Sri Lanka is not applying for the support, the technical support, so I assume this means the forensic investigators, which probably states would be ready to land. So it's available, and it's just simply not requested. And this, I would say, is it begs for a more holistic approach to truth and reconciliation and reparations. So, you know, there's only so much that an accountability, and for me it's been the experience of my nearly 20 years career in the field of international criminal law, human rights investigations. It's not all that we make it to be. It's great to have this, it's part of the conversation, but even when it is achieved, it's definitely not the end of the road. The road is long, and you know, I'll come back to my initial point on decolonizing the conversation around this, because these processes are very much held in the north, and you know, it's one thing, it's great, and sometimes when you cannot have the conversation in the country where the crimes occur, it's good to have this. So I don't want to slag it completely either, but it's only part of the process.
Thank you very much. I believe there is another question from online.
So this question is from Alex A. How do you see the role of survivors and victim communities in shaping and demanding international accountability mechanisms?
Well, I mean, you see, so me, I say I don't trust government, okay? Well, if you see it in the past 30 years, for example, you take Rwanda, or you take some example where obviously there have been mass crimes. It's true that governments sometimes have been, for example, or let's talk about Syria and Germany, where government have, through asylum, have made processes to build cases and have taken the lead. But to go back to the questions, most of the effort, at least outside the international court, at the national level, I would say, probably statistically, most of the effort are led by civil society. Take in France, it's a civil organization of Rwandan survivors who fought for so many years for the French state because of cultural, the story of France with Rwanda, to decide to start doing UJ cases in France on alleged genocidaires living in France, and there were many. I believe without Alain Gauthier, his wife, and their organization in France, but me, I believe there would be no case today on that. Same in France for all the work of the lawyer on Syria and on Al-Assad. I mean, so we can multiply the examples. Someone talk about the Gambia. Everything is led by civil society. On Liberia, we have led civil society. So me, I think that civil society is completely key in driving the effort. And maybe we can make the parallel with everything all your organization have been doing at the UN, but not only. I know all the lobby. Let's think be your children. If nothing happened, they will be there. They will not even have been alive at that time, and still they will carry, because this is within your community and you care. And we see that throughout the cases and the different situations. And I think this is our legitimacy as, again, as a Swiss, French, white male. I have no legitimacy to represent anyone if it's not working with the communities, but the communities have the legitimacy, and me, it's very clear to me, 100%, this needs to be the pivotal central role.
Thank you very much. I think we have time for one more question from online.
So this question is also from Alex A. So he asks, in your opinion, do you still see lack of evidence as the main reason accountability is held at bay, even with all the mass graves and the many evidence found throughout the year?
You know, there is, we all know, because we have been the investigation on cases, the difficulty is have been crimes to the situation where you have a case in court with evidence which basically is strong enough to secure you a conviction, okay? And this is the problem. To answer the question, this is the problem, is that there is a gap there. And everybody could maybe knows, and maybe it's true, but maybe you don't have enough evidence. This is a problem. And maybe one example in mind for me, which was so interesting, is Cambodia for that, where you ask anyone who knows a little bit about internet, even mainstream, what are the genocide today? Maybe they will or will not mention Sri Lanka, but they will mention Holocaust, and probably they will mention Rwanda, and probably they will mention Khmer Rouge, okay? In the kind of understanding, Khmer Rouge killed 1.5 million out of 4 in their own country. Yes, there was a genocide. Well, and they got finally a conviction for genocide in the East Squid group. In Cambodia, where will you get, you know what I mean? So this is the thing, this is the trick, is that, you know, you need, as I mentioned, you need, you know, good evidence, you need, you know, as Julie mentioned, to talk for hours and days to people and check and really make sure that they were there, that they saw, that their recollection is good enough, credible enough, corroborated. It's not easy. So, and this is, I think, very important, and I agree fully. Maybe sometime at the end, because of some reasons, well, you are not there yet for a criminal case, and I agree. It's not the end, it's not this or nothing, right? There could be other ways for justice and accountability.
I also want to of universal jurisdiction cases, which is that, you know, those pôles de crime de guerre, for example, in my own jurisdiction, was created by the parquet in Paris. When you look at the means available to them to actually proceed with those trials, you might cry. They have, I think, a task force of under 10 investigators for all of the possible cases, a couple of magistrates. They're very poorly staffed and funded. They have to make choices as well, because those trials occur in a specific court in Paris. There can only be 2 of those per year. So you have to think also in terms of those accountability cases are competing against one another. There are decisions that are made on the jurisdictional level. What will we do this year? Rwanda, Syria, Sri Lanka, you know. So that's part of the issue here. And as well, yes, you're right, Alain, I think it takes a lot to take a case to court. And crime-based evidence is not lacking, and I think even the government of Sri Lanka agrees. But the rest of the job is, still to be done, and that's the biggest part of the job. It's linking, finding the persons responsible, and finding the linkage evidence. So there's still work to be done.
But the deliberate killing of a large number of people from a particular nation or ethnic group with the aim of destroying that nation. So yes, I know what happened in Sri Lanka. I'm aware of Shenmani. I'm aware of all these things. But does it strictly come within this definition? And as I understand, that is one of the reasons the Tamil lawyers who are being forced by the Canadian Tamils and other Tamils diaspora to push for genocide are unable to pursue that, as okay, there were killings, no doubt, but as to whether it falls within this definition is in doubt. And then another random thought. Mr. Alain said governments are not interested. Well, why would a government be interested in pursuing an investigation that will implicate itself? Right? I mean, if you are the head of government, are you going to open up and say, yes, let's bring international investigators, let's this thing, and let's blame the army? So we are both looking at it from two different angles, and if you are wearing the shoes of the other, you will be reluctant. The government knows who did it, so why would it, as the government, would you expect it to open up and expose its guilt, or is it only natural that they would like to delay, derail, and cover up? Government knows why it would want to investigate. Yeah, and also one of you said the Tamils are very enthusiastic all across the world. But where has it taken the Tamils? For 15, 20 years, they have been talking and demonstrating. You see, in the bigger scheme of things, Sri Lanka is insignificant, Tamils are less insignificant, and I'm not saying it in a very demeaning way, but in the global context. And just see what's happening in Gaza and Ukraine. They're all helpless. So anyhow, some idiotic thoughts, but thank you for the floor.
Thank you for your question. Any responses?
Okay, so let me just tell you something about genocide, without going into the Sri Lankan, because I don't know enough. But I think on genocide, I think all of us have been in the field a bit frustrated, maybe what's going on as well now, currently. In a way, there is in international law, I think everybody, probably you think, and most people think that genocide is the crimes of crimes. Well, there was no classification under international law, and there have been sometimes. I think it's a bit of complicated, because you can think about, for example, with Bosnian, and if it's not genocide, it's nothing. Me, I have never worked in a genocide case in court. Okay, all our cases in court were war crimes or crimes against humanity, both at the international level or national level where I've been working. And I think that genocide, as obviously very clear as a power the world itself. And in a way, me, I'm very, very, as you have understood, I'm very doubtful of, I don't trust government. And genocide then, it's in a way often, and now we're seeing with Israel, the work of International Court of Justice, right? Where they have to deal with that. But this is different, right? International Court of Justice is not the International Criminal Court. It's a mechanism between states where now they are accusing each other of genocide. And for me, I think that at least for the victims I have been working with over the years, I can tell you again, it was never a genocide case in court, but it was crimes against humanity. Crimes against humanity is crimes which happened in a systematic, widespread way against civilians. I mean, crimes against humanity are worth pursuing. And me, I think that sometimes we should not lose sight of the fact that, genocide sometimes is all over the conversation, but it should not swallow the entire oxygen and sphere. And then on your second point, I mean, you said, well, nobody cares about Sri Lanka, and of course the Sri Lankan government will not do anything. You're absolutely right on your both points. But me, I'm coming from a point where, talk about Liberia. When I give conferences, people don't even know where Liberia is. They ask me questions about Libya. They mix up Liberia and Libya. You ask 100% where Sri Lanka is, I expect 80% of people to more or less tell you where Sri Lanka is. Liberia, nobody knows, more or less, right? And I can tell you that civil society was not organized like the way the Sri Lanka Tamil civil society is organized, and yet we managed to get some, humbly, but some justice for the Liberian people. And you mentioned, I worked on Hissen Abre, the Chadian. Well, in the 80s it was important, Chad, because it was with the United States against Libya and the Russian, and they were with the French. But later nobody cared about Chad. Well, it's civil society. So I think people care or don't care, it's a small, insignificant, and doesn't matter. And of course you're right, it's because people, Sri Lanka will not bring justice, that indeed the Tamil need to get organized, what they are doing, and get justice. So I think you're completely right on your point, but still me, I think that doesn't matter if a country is small, not small, important, not important. It's important for victims. They are entitled. International conventions give them rights, and we should pursue it.
One note here. So the crime of genocide is the intent to destroy in whole or part members of a protective group. From the definition, there are 4 protective groups: ethnic, religious, national, I'm missing one, cultural?
Racial.
Sorry? Racial, thank you. And so you can kill one person, and if you can prove that your intent was to destroy in whole or in part, the crime of genocide can be committed. So it's a crime of intent. So my suggestion, working in this field for over a decade, including on genocide cases, is to maybe not dwell so much on the legal qualifications of the crimes, bring the facts, initiate the proceedings, and, if the facts are well documented, you have linkage evidence or evidence on the intent of why the crimes were committed, you will have such legal findings determined by a court of law. I just want to say this. Thank you. Pardon? Yes, and only by a court of law.
Thank you so much, everyone. I believe we are now at time. First and foremost, our heartfelt gratitude and thanks to all our expert panelists who joined us today. We truly appreciate you all for taking the time out of your busy schedules and being here with us. Thank you. And thank you to all members of the media, human rights activists, Tamil diaspora organization representatives, NGOs, supporters, and guests for joining us today both in person and virtually at the Geneva Press Club to witness this panel on advancing international accountability in Sri Lanka. We truly hope you all found this session valuable. In terms of closing remarks, we hope this session has fostered an understanding of the current situation in Sri Lanka, highlighted the human rights and international law implications, emphasizing the importance of global solidarity, and empowered you all with exploring avenues to enhance and complement the multilateral system's ability to advance international accountability in Sri Lanka. As we conclude today's panel, on behalf of NCCT, we would like to emphasize the continuous need to advocate for achieving international recognition, international accountability, and remedial justice for crimes against humanity, war crimes, and crimes of genocide, and the importance of achieving a permanent political solution grounded in the Tamil people's inalienable right to self-determination, one that addresses Tamil people's legitimate political aspirations in their traditional homeland on the island of Sri Lanka and contribute to sustainable peace and stability in the Indo-Pacific region. Thank you all once again for joining us and hope you have a wonderful rest of the day.